Was this what the vague posting was about, or is there more coming? This was not what it was about. There is more coming, one. And there's another vague post, more coming, two. There's a lot of memes in the pipeline right now. All of it very, very, very bad for the two main parties involved on the other side of this. Over your position, the defendant's counsel would be inconvenienced by having to travel to Miami twice if plaintiff's deposition were to be held on November 21st, 24th, or 25th, and defendant's on November 6th has no validity. Your travel preferences are not good cause under Rule 26C to reschedule defendant's properly noticed and agreed deposition or insist that plaintiff's deposition be in the same week, particularly where local counsel is available. I like how she's saying that my lawyer's traveling is not reason for me to be inconvenienced, but the plaintiff herself traveling to the venue that she filed the court case. I don't choose where to get sued. She chooses the venue. Hers would be inconvenient. That's hilarious. Destiny, what do you think their intention is here? Stop asking me this. Why do I keep having to repeat myself? Her goal is humiliation, reputation destruction, and wasting my money. That's the only thing. She's abusing the court system to play this game, to do. That's all she wants. This is very cleanly obvious. Over your position, the defendant's counsel would be inconvenienced by having to travel to Miami twice if plaintiff's deposition were to be held on November 21st, 24th, or 25th, and defendant's on November 6th has no validity. Your travel preferences are not good cause under Rule 26C to reschedule defendant's properly noticed and agreed deposition or insist that plaintiff's deposition be in the same week, particularly where local counsel is available. I like how she's saying that my lawyer's traveling is not reason for me to be inconvenienced, but the plaintiff herself traveling to the venue that she filed the court case. I don't choose where to get sued. She chooses the venue. Hers would be inconvenient. That's hilarious. Destiny, what do you think their intention is here? Stop asking me this. Why do I keep having to repeat myself? Her goal is humiliation, reputation destruction, and wasting my money. That's the only thing. She's abusing the court system to play this game, to do. That's all she wants. This is very cleanly obvious. A post identifying plaintiff's spouse by her legal name. So the fuck what? Protective orders are not here to protect your name. Protective orders exist to protect your identity, to shield your identity from the public. You've already made public. This is why I'm saying the whole protective order, all of this is just a fucking game. Like, imagine if Pixie were to join a company called Tankies for the Destruction of the Democratic Party in the USA, but she joins under her real name. And imagine I tweet out and I'm like, oh my God, wow, look at this. Pixie's joined Tankies for America, good job. And now they're like, oh, well, we're filing a lawsuit or we're filing another protective order. You just linked to her real name. It's like, this is so stupid. Well, like, the protective order is not here to hide doxing. That's not a real thing, doxing, for a court case. In a court case, you're supposed to make your identity known to the public. You're filing in a public forum. All right. Andrew. Bushido Blade, earning that paycheck. I need your take on the movie Synecdoche, New York. I only watched it once. I couldn't bring myself to watch it a second time. Maybe I will revisit it in the future. That's a very depressing, very thought-provoking movie. I don't know who I don't know who the intended audience is, or what it's necessarily supposed to communicate. I don't know enough about Kaufman to know his feelings on things or what he's trying to communicate. The idea that some people or artists or himself thinks that they're more special than they actually are, that your life really is just like everybody else's. Your purpose is to come here to live the same life everyone else does and die. You're no more special, no less special than any other person at the end, or as you approach the end. Every individual is more or less replaceable with anybody else. Different actors can swap in for different people. It really doesn't matter. Everybody replays the same things. Every experience is the same. There's like a shared human experience that all of us go through, and wasting your time searching for some deeper, greater thing that is extra special that you or anything else is. Yeah, I don't know. That's, isn't that beautiful? Maybe. It's either very depressing or very beautiful. My first take on it was very depressing. But it might be one of those things where it's like you go through your journey, your stages of like, oh no, God isn't real. Well, that means that life sucks. And then it's like, well, actually, if God isn't real and life still exists in all of its beauty and everything else, like, wow, it's actually so much cooler that, we could be sharing this experience in such a seemingly random way. Like, it actually makes it even cool. Maybe I would feel that way on a second watch. I'm not sure. Yeah. Did you see Kaufman's movie, I'm Thinking of Ending Things? No, but I've heard really good things about it. Thoughts on Jojo Rabbit? Jojo Rabbit's a really good movie. But I think everybody thinks that. It's like a super accessible, super good movie, yeah. I thought you didn't want to debate over abortion. Did anything change or are you bored? So part of, as this court case winds down, part of getting back into the swing of things is you have to build up like a repertoire of events because it gives you credibility so people can see that you're not like radioactive anymore. So the reason why I'm agreeing to do debates and, you know, events and everything is because now it's like, okay, well, Destiny, is he a rapist or what's like the verdict on him? Well, if you can look back like the past like 2 to 3 months and you're like, oh, okay, well, he's appearing with all these people and everybody seems to think that everything's okay. It's like, okay, that's the, yeah, sort of rolling through events or whatever. Is Hunter x Hunter in your top 5 Japanese cartoons? No, actually. I actually think Hunter x Hunter to me, I think is like, I don't think it's a good anime. I don't know if I'd recommend it. It's a lot of slop, but there are a few really cool moments. That's how I feel about Hunter x Hunter. That's all I can say, yeah. There's a lot of slop in Hunter x Hunter, but there are a few really cool moments. That's how I feel, yeah. I think the cool moments almost make it worth it, though. I think it's worth it. I don't regret watching it. There's a lot of slop. Hunter x Hunter is the ultimate wasted potential of an anime. The world is so cool. Excuse me, but the new chapter came out, so maybe he's working on it, okay? Oh, I was going to do some camera shit. We'll do it after this. Fuck it. All right. Stephen K. Bonnell II's motion for a protective order to coordinate deposition scheduling. Oh my God, there's been so many memes in the background. However, I have to read through these first to see what I can talk about or not, okay? Defendant Stephen K. Bonnell II, Bonnell, by and through undersigned counsel, respectively moves under Federal Rules of Civil Procedure 26C for a protective order, directing that the parties' respective depositions be coordinated and conducted during the same week to avoid unnecessary burden and expense. In support thereof, Bonnell states as follows. Let's check real quick. Federal Rules of Civil Procedure. So civil procedure is like the rules for basically doing civil lawsuits. The federal rules for civil procedure for the federal jurisdiction. Fuck. What was it? 26C. Not that one. 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 Protective orders. A party or any person from whom discovery is sought may move for protective order in the court where the action is pending or as an alternate. The motion must include certification to confer with other parties. Okay, all right, who cares? Introduction. Bonnell regrets to have to seek court intervention here, but plaintiff's recalcitrance has left him with no choice. On November 3rd, yesterday, 2025, plaintiff failed and refused to appear for her duly noticed deposition in Miami, Florida. Counsel for Bonnell spent significant time and resources preparing for the deposition, traveling across the country, and appearing for the deposition as noticed. Noticed meaning that we filed paperwork with the court noticing, saying, hey, there will be a deposition on November 3rd of the plaintiff, of Pixie. Now, the issue is that if you disagree with that noticing of that deposition, I'm sure there are a ton of other ways to do this, but for federal rules, you can quash that, meaning you can file some paperwork with the court, I think, to say, we're not going to show up for that. That's not happening. And then I think you can fight on that. I think is that the legal term is quashing it? or there might be another thing you file, Kefka or somebody might know. But we noticed that the deposition was going to happen on the 3rd, and she just didn't show up. They didn't produce her. I don't know if that noticed thing is here or where. I don't know if that was filed on one of these or... I'm sure it's somewhere here. Neither plaintiff nor her counsel bothered to show up, and plaintiff further failed to seek a protective order to prevent her deposition from going forward. Despite plaintiff's refusal to appear for her own deposition, and despite that Bunnell has made every effort to accommodate plaintiff's availability and minimize travel costs, plaintiff ignored a valid deposition notice. Were her lawyers there? Nope. At the same time, plaintiff seeks to force Bunnell to appear for his deposition on November 6, 2025. Plaintiff cannot have it both ways. For the reasons stated herein, Bunnell respectively requests that the court issue a protective order directing that the depositions of plaintiff and Bunnell be conducted during the same week, preferably November 24th and 25th, respectively, in Miami, Florida. Indeed, plaintiff and her counsel previously represented that they are available for deposition on those dates. God, I hope that he publishes all the emails. There's like 20 fucking exhibits for this. Dude, the emails back and forth are so fucking crazy. Isn't notice just when you have a sheriff or constable deliver the summons to the party, or am I misunderstanding? I think notice can mean different things, but in this case, that's what noticing means. Factual background. On September 17th, 2025, attorney Joan S. Peters, on behalf of plaintiff, inquired about scheduling Bunnell's deposition in Miami between October 22nd, 2025 and November 19th, 2025. On September 22nd, 2025, the undersigned responded to Ms. Peters, writing that Bunnell was generally... Oh my God, bro. Okay, good. These emails... Dude, these emails are so fucking crazy, okay? Holy shit. They're so crazy. They're so crazy, dude. The undersigned responded to Ms. Peters, writing that Bunnell was generally available during the first week of November, and suggested that the parties schedule plaintiff's deposition for the same week. On September 26, 2025, Ms. Peters indicated that plaintiff would like to take Bunnell's deposition on November 5th or 6th, 2025, but claimed that plaintiff would not be available for deposition during the entire month of November because she was going to be out of state. In response, counsel for Bunnell agreed to hold November 6th for Bunnell's deposition in Miami. However, given plaintiff's counsel's representation that their client was not available for a deposition in Miami during the entire month of November, the counsel for Bunnell asked plaintiff's counsel to provide her availability in October. In response, on September 29th, 2025, plaintiff's counsel noticed Bunnell's deposition for November 6th, 2025, meaning so they said, we're going to depose you on November 6th, right? That's what we did for her on November 3rd. But now that she didn't show up for hers, this is why he's filing this protective order to say, oh, well, now I'm not going to show up for mine, right? She should have filed an order like this if she wanted to skip her deposition yesterday. Deposition for November 6, 2025, and despite Ms. Peters' previous representation that plaintiff would be out of state for the entire month of November, plaintiff's counsel offered a single date, November 21st, 2025, for plaintiff's deposition in Miami. The undersigned promptly advised Ms. Peters of a conflict on November 21st, 2025, due to a previously scheduled mediation in Los Angeles that day. I don't understand. How can you not show up for deposition? Are you summoned by the court? Nope, not really, not yet. This is just civil stuff. The undersigned again inquired about plaintiff's availability to sit for a deposition in Miami anytime in October. Has he referenced any exhibits here? Oh, Exhibit F, Exhibit E. Oh, shit. Should I be clicking through these as he's... Okay, fuck. Have we gotten all the way to Exhibit E? Is he going in order? Exhibit D, Exhibit B, Exhibit A. Okay, let's read through some of these. Beware, the exhibit contains unredacted email addresses. It doesn't matter, it's zero public filings. We're up through Exhibit F. The undersigned again inquired about plaintiff's availability to serve a deposition in Miami anytime in October. Okay. Exhibit A. From Peters, Joan. I think these read from bottom to top. Sincerely. Wait, fuck, am I retarded? To Andrew from Peter. From Joan. Is this... But then it says sincerely at the bottom. I hate the way the email... There needs to be a standard formatting for emails. I don't know why this hasn't happened yet. Okay. I think this is from Joan. Well, wait, hold on. I don't have to be retarded. Hold on. I'm not retarded. I can just read what he was referencing. And Exhibit A. Okay. Inquired about scheduling. Okay. This is from Joan. It says from Joan. Counsel. The discovery cutoff date, as per the court scheduling order, is December 16th. With that in mind, we would appreciate it if you could provide 3 available dates for the defendant to be deposed in Miami, that's me, between October 22nd and November 19th. Once we have agreed on a mutually available date, we will provide the notice of deposition. Thank you. And then on Wednesday, September 17th, she also wrote... Oh, wait, this was earlier, so I should be reading these bottom to top. Fuck me. No, I shouldn't be. Never mind. 2:34 p.m. September 7th. Wait. Oh, no, I should be reading this bottom to top. I hate emails. Sorry. Forget this. It is bottom to top. My bad. Okay. Sorry. This is from Andrew. Just forget everything. Wipe your mind, okay? Joan. Mr. Bonnell could have responded haphazardly to the discovery request you served and made an incomplete document production, just as plaintiff has done in response to the discovery demands that we served, see attached letter. Instead, Bonnell is complying with his discovery obligations and making a robust and timely document production. A link to download Bonnell's production will follow in a separate email. Any delay in the progress of this case is of your own doing. Finally, there was no threat in my last email. We will proceed accordingly. I don't remember what they were fighting about here, but we fought a lot about discovery. My discovery, flawless, beautiful, formatted beautifully, easily readable, just perfect. Her discovery, chaotic mess, incomplete, multiple items, still outstanding, months in, hasn't produced, lying about things. Just horrible, okay? So mine is just impeccable, okay? So her response is, counsel. So 5 days later. We are in the process of reviewing your objections to plaintiff's September 5th document production, as set forth in your letter, dated September 12th, 2025. We will be submitting an amended response to interrogatories, as well as a supplemental document production on September 19th. After receiving, please advise as to whether you would still like to have a meet and confer regarding any remaining objections. On a separate matter, we have been collecting, reviewing, and organizing documents responsive to your 12 requests for documents, and your subpoena duces tecum, or whatever, on Lauren Hayden. This process has taken significantly longer than previously anticipated. We now anticipate being able to produce responsive, non-privileged documents on or before September 26th. This production, by the way, is also dog shit, horrible. Destiny, your counsel is putting together the productions, right? Not you personally. Kind of. I provide them the material and then they put together the actual production. But like, I mean, how well I provide material to them determines how well they can provide it to the other people. Like if I just sent them like a CSV with everything all mixed and fucked or whatever, as opposed to like more needed to read documents so they can parse. The more work, I don't know if there's like a rule or not, but it seems to be, from my perception, the more work you're willing to do, the less work your lawyers have to do, and then the less you have to pay them. Like if you hand them a bunch of shit, then maybe they can make sense of it all, but you're just going to be paying them to sort through everything to do more work, and they might misunderstand something. So it's better to like do as much work as you can, homework to send to them. Yeah. Counsel. The discovery cutoff date, as per the court's scheduling orders, is December 16th. With that in mind, we would appreciate if you could provide 3 available dates for the defendant to be deposed in Miami between October 22nd and November 19th. Once we've agreed on a mutually available date, we will provide the notice of deposition. Thank you, Joan. Exhibit B. September 17th. Okay, so that's these emails. This is from Carlos. Good morning. I hope on September 19th. Good morning. I hope you are doing well. Andrew, I'm following up on the deposition dates for your client, as mentioned below. Please let us know, and thank you, Carlos. Andrew responds a few days later, September 22nd. Our client is generally available during the week of November 3rd. With the exception of November 4th, I have a court hearing in another matter. We will endeavor to make Mr. Bonnell available for deposition any day that week. While we are in Miami, let's also set plaintiff's deposition for the same week. Please let us know what works for you and her. Thank you. Right? So now, for my lawyers to do the deposition of Pixie and to be present for my deposition, they have to fly in from California. So it's just like nice, and it just makes sense to schedule everything the same week, right? It just makes sense, right? You would think. You would think.
We would like to depose your client in Miami on November 5th or 6th. Please confirm availability. Our client will be in Illinois, not Miami, in November. She is available to be deposed remotely or in person in Illinois on November 14th. Thanks. Okay. Venue is the geographical location that you choose to hear a case. So jurisdiction is, do they have the legal authority? Venue is the geographical authority. I don't know if you'd say that. There's probably a more specific term that I'm fucking up. But I'm being sued on the federal level, okay? Federally, meaning in federal court, U.S. court. And the venue that they've chosen, we have availed ourselves to the federal court in the Southern District of Florida, okay? This is where the court case is happening. This is where you've decided to sue me. What do you mean you can't be in Florida for your deposition? Why would we go to Illinois? The court case is happening here. It's your chosen venue and you're the plaintiff. Why? What do you mean you can't be in Florida for your deposition? Okay. Exhibit D. Andrew responds, "Thank you, Joan. Let's hold November 6th for Mr. Bonnell's deposition in Miami. If your client is not available for deposition in Miami during the entire month of November, please provide us with her availability to sit for deposition in Miami in October." Exhibit E. Please take notice that on November, so right after that, I think they noticed, this might have been filed with the court. They noticed, I think it was, they noticed our deposition, or immediately, right? Now you're noticed for November 6th, okay? But now keep in mind, we don't even know, well, hold on, wait, when are we deposing Pixie? Excuse me, right? So they noticed the deposition for me for 2 days, right? Pursuant to Rule 30b-1, Stephen Bonnell will be deposed on this date. Works for you, September 26th. Let's hold November 6th. Okay. Joan says, attached, please find a notice of deposition for defendant's deposition on November 6th. Plaintiff can be available in Miami on November 21st for her deposition. Regards, Joan. Or Joanne. Okay. Jesus, these fucking emails. Wait, is this even saying anything new? This one's not. September 29th. Okay. Okay, so we're caught up in the exhibits. In response, on September 29th, 2025, Plaintiff's Counsel noticed Bonnell's deposition for November 6th, 2025. And despite Ms. Peters' previous representation that plaintiff would be out of state for the entire month of November, Plaintiff's Counsel offered a single date, November 21st, 2025, for plaintiff's deposition in Miami. The undersigned promptly advised Ms. Peters of a conflict on November 21st, 2025, due to a previously scheduled mediation in Los Angeles that day. Exhibit F. Okay, whatever. We already read this one. The undersigned counsel again inquired about plaintiff's availability to sit for a deposition in Miami anytime in October. The next day, on September 30th, 2025, Ms. Peters offered additional availability for plaintiff's deposition in November, stating that plaintiff can also be available to be deposed in Miami on November 24th or 25th. This is Exhibit G. Okay, so on September 30th, she replies, Joanne? Plaintiff can also be available to be deposed in Miami on November 24th or 25th. Keep in mind she said originally she wasn't available for the entire month of November, but okay. Plaintiff can also be available to be deposed in Miami on November 24th or 25th. Other than those 3 dates, November 21st, 24th, or 25th, plaintiff is not available in Miami. She can also be available for remote deposition on October 24th or November 7th or 14th. We're not doing remote depositions, okay? Fuck that. Cringe, all right? On October 2nd, 2025, In light of plaintiff's newly offered availability at the end of November, the undersigned suggested in an email to plaintiff's other attorney of record, Carlos A. Garcia Perez, that both plaintiffs and Bunnell's depositions be conducted in Miami on November 24th and 25th, respectively, to avoid having to make multiple trips to Miami, only a couple of weeks apart. On October 3rd, 2025, Mr. Garcia Perez rejected the proposal and insisted that Bunnell's deposition proceed on November 6th. Okay. H and I. So on October 1st, Carlos Garcia said, "Good morning. I hope everyone is doing well. Feel free to unilaterally send the notice of deposition, which frankly is unneeded and a waste of time. Before you go that route, please give us a couple days to hopefully provide additional dates. October is difficult because of conflicts related to other matters, a personal matter, and our client's availability. Thank you, Carlos." So I think this is in response to Andrew saying that we're just going to notice Pixie's deposition for the 3rd, I guess, because they're like fighting us on dates. That other email's not in here though, but okay. And then Andrew says on October 1st, "Good morning, Carlos. Waiting a couple more days is fine, but if we don't have proposed dates for plaintiff's in-person deposition in Miami in October, by this Friday, we will issue a deposition notice and select a date for plaintiff's deposition that works for Mr. Bunnell and his counsel. In addition to still needing to provide her availability for deposition, plaintiff and her counsel owe us a considerable amount of discovery, as raised in our prior correspondence." So just as a thing, Pixie said this, I think Lauren has said this. Gisticle said this. Kiwi Farms have said this. The commentary, everybody, all the retarded Kiwi Farms lawyers, the criminally fat guy, all these people have said, Destiny really doesn't want Discovery. Discovery's going to destroy Destiny. It's going to be horrible. This is what everybody thought. I've produced all of my Discovery. Pixie's the one that hasn't produced almost anything. And they are super far behind on all. They still haven't provided. We don't even have Abby's original text. That's supposedly the only evidence they're using for this case. We don't even have that unredacted. Right? They've given us nothing. This is like a joke. This is like a meme. In addition to still needing to provide her availability for deposition, plaintiff and her counsel owe us a considerable amount of discovery, as raised in our prior correspondence. See email from Andy Bretler to Joanne Peters et al., dated December 27, 2025, an attached letter. Among other things, 1, plaintiff's document production is still incomplete. 2, plaintiff must amend her responses to the request for production. 3, Lauren Hayden's document production in response to the subpoena is long overdue. And 4, plaintiff's counsel has failed to provide current contact information for Abby MC. Please advise when we can expect compliance with these discovery obligations. Thank you, sincerely, Andrew. This is October 1st, so it was about a month and 3 days ago. Carlos writes, "Good morning, I hope you all are well. I think Carlos, I don't know how he gets, I don't know how he's related to all these people. I just want to be clear for opposing counsel. Carlos seems like a dude who's just doing his job. Okay? Seems like a dude who's doing his job. The Joanne Peters person, the immigration attorney from Puerto Rico, she's the one with the huge fucking chip on her shoulder. I don't know why or what her issue is, or again, I think this is like the personal family friend or whatever. But Carlos seems like he's trying to do his job. You know, this is my impression, but. Good morning, I hope you all are well. I'm following up on the previous email. Regarding the deposition of plaintiff, she has made herself available to be deposed in Miami on November 21st, 24th, or 25th. Although you stated that you have a conflict with the November 21st date, you provided no reason for your unavailability on November 24th or 25th. Moreover, I respectfully remind you that you initially requested dates in November for plaintiff's deposition. She's also available on November 7th and 14th via Zoom. This is an unbelievable statement though, okay? Requiring plaintiff to travel to Florida in October and certain dates in November would pose an undue burden to her, given that she currently resides out of state. She moved? She sued me in the state of Florida. Is this no longer a convenient venue for you? How can you possibly say that it's inconvenient to appear in the venue that you've chosen to avail yourself to file a lawsuit against me? Excuse me? Her travel to Miami would entail 16 hours plus the time on deposition, causing her to miss important classes in school, among other issues. Oh, so she could go to school? Is she going to law school? It's got to be a master's, right? Because she's already done all of her undergraduate degrees. So what does she need the money for or the fundraiser for? If she has the money to go to law school, if they've spent easily over 150,000 so far on all of their lawyer shit, what the fuck was her fundraiser for? What are we doing here? What the fuck is her life? Her travel to Miami would entail 16 hours plus the time on deposition, causing her to miss important classes in school, among other issues. Accordingly, and for the reasons stated on my previous email, October will be very difficult to coordinate unless the deposition is taken by Zoom on October 24th. Also, November 7th and 14th may work by Zoom. As you are aware, if a dispute between the parties arises as to the location of a deposition, the court may prescribe the time, place, and terms of the deposition to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. I am so curious if 26C, if this federal rule has ever been cited to say that somebody can't show up for a deposition in the state that they filed a case in. That would be crazy to me. Maybe it has, but I don't. That's wild to me. Similarly, wait, so she's in school in another state? Yeah, how fucking annoying. Isn't it cute that she can just frolic along and go live her life and do whatever stupid, retarded fucking shit she wants to do in her life while she fucking just sits here and wastes all my bullshit on whatever. It's fun. Nice. Good times. Similarly, Rule 30b-4 provides that the parties may stipulate, or the court may, on motion order, that a deposition be taken by telephone or other remote means. I sincerely hope that this issue can be resolved without the court's intervention. Finally, and on a separate matter, and for attorneys' eyes only, we recently obtained Abby's last known address. This didn't work, by the way. It was bullshit. Thank you, and if you need to further discuss these issues, we are available next week for a phone call with the exception of Tuesday. Andrew said, Carlos, regardless of where plaintiff now resides, she filed this lawsuit in the Southern District of Florida. Our client is entitled to take her deposition there in person. Her argument that it would be an undue burden to sit for a deposition in Miami because it would force her to miss classes just doesn't fly. Nevertheless, to accommodate her schedule, we will agree to take plaintiff's deposition in Miami on November 24th. However, we request that Mr. Bonnell's deposition be rescheduled to November 25th to minimize the undue financial burden on him and to limit the number of trips we'll need to make to Miami. Please confirm this is acceptable. Thank you. So I think this is reasonable, right? So we said like, okay, yeah, I'm available on the 6th. And they're like, sorry, we're busy the whole month. And they're like, actually, we can do maybe this. Okay, you want to do the 25th? Okay, fine. Then let's do Bonnell's on the 26th, okay? Not when Joanne is making the call, though. Absolutely not, okay? From Carlos. Good morning. I hope everyone's doing well. Let's please, let's please not confuse the issues. Your client's deposition is set for November 6th, as agreed by the parties. The issue is the method and dates of our client's deposition. You now have 5 dates to pick when to depose our client. Please let us know when you're going to take your deposition. As to the hardship, it's the negative impact that it will cause on her studies, among other issues. I hope we can all appreciate and understand that being the case. Again, your client's deposition is set for November 6th. Please let us know when you're going to take our client's deposition. Thank you, and I hope you have a good day, Carlos. This is what I mean when I say every fucking thing is a fucking game fight to these people. Like, what the fuck? Really? This is the game we're going to play now? That was Exhibit I. In the afternoon on the same day, the undersigned requested a telephonic meet and confer conference with plaintiff's counsel to discuss the apparent stalemate in scheduling both depositions during the week of November 3rd, 2025, or both during the week of November 24th to minimize unnecessary travel and reduce expenses. In response to the meet and confer request, on October 7th, Mr. Garcia Perez attempted to limit the scope of the conference to the scheduling of plaintiff's deposition. Mr. Garcia Perez once again insisted that Bonnell's deposition proceed on November 6th, writing, "We do not agree to change or cancel your client's deposition date." Over the course of several emails, counsel summarized their respective arguments regarding the deposition scheduling issue. So in response to the "let's not confuse the issues," Andrew says, Carlos, we aren't confusing the issues. We're trying to schedule Mr. Bonnell's deposition and plaintiff's deposition around the same time in Miami for practical reasons. In that regard, plaintiff can either appear for an in-person deposition during the week of November 3rd if Mr. Bonnell's deposition is going to take place on November 6th, or she can appear for deposition in Miami on November 24th if plaintiff wishes to take Mr. Bonnell's deposition there on November 25th. If your client is unwilling to sit for an in-person deposition in Miami, where she filed her lawsuit, any time this month, we're not going to agree to produce Mr. Bonnell for an in-person deposition in Miami on November 6th, only to have to fly back there 2 weeks later to take plaintiff's deposition. Plaintiff's position is simply unreasonable. Happy to discuss by phone in advance of Mr. Bonnell seeking relief from the court. Please advise of your availability for a meet and confer call on Monday. Thank you. Sincerely, Andy B. Andrew writes, Carlos suggested a call tomorrow at 10 a.m. PDT, 1 p.m. EDT. All those who are available to participate can use my dial-in. Use his number, no pin needed. Joanne says, can we speak at noon EDT tomorrow instead of 1? Andrew says, Carlos requested a call at 1 p.m. EDT tomorrow. Does 12 p.m. also work for him? I don't know if Joanne and Carlos are communicating all the time because sometimes they say two different things. Somebody in chat says, just for all clear how insane the 16-hour claim is, I live in Ireland. The flight to the U.S. is between 7 and 9 hours. I can fly across the world faster than she can cross the states. My guess is she's driving. I don't know why, but... Joanne says, sorry, I meant to say that noon works for Carlos. And then Andrew says, I know 1 p.m. works for him. That's time you requested. You asked me to call at 12. I'd like to make sure Carlos is available. Yes, 1 p.m. works for Carlos. Okay, so the scheduling time. Okay. And then on October 6th, Andrew states again, great, happy to move the call to 9 a.m. PDT, 12 p.m. EDT tomorrow. In addition to discussing the deposition scheduling matter, we'll also use the call tomorrow as an opportunity to meet and confer with you regarding 1, plaintiff's incomplete document production, 2, plaintiff's all the things that they haven't provided us still. Carlos responds on October 7th. Good morning. I hope you're doing well. The only issue on the deposition schedule is when and how you will take plaintiff's deposition. Your client deposition date was agreed by the parties and properly noticed. Respectfully, only a court order or an agreement by the parties may cancel or move the deposition date. We do not agree to change or cancel your client's deposition date. Thank you, and we are looking forward to the conversation at 12. Carlos. Okay. And then Andrew responds, well, not so, Carlos. The main purpose of our call is to discuss deposition scheduling of both parties as laid out in my email at October 3rd at 3:23 p.m. We also intend to cover points 1 through 4 of my email from last night. Speak soon. Carlos writes, again, your client's deposition date is a non-issue unless it's agreed by the parties or there is a court order. We have never agreed to change your client's deposition date. Your self-serving email does not change that fact. Thank you. Andrew writes, we will discuss at 9 p.m. PDT, but as indicated previously, we are not going to agree to produce Mr. Bonnell for an in-person deposition in Miami on November 6th, only to have to fly back there 2 weeks later to take plaintiff's deposition. The depositions will be conducted close in time. Plaintiff can decide whether she wants the depositions to occur at the beginning of November or at the end. Now we get Joanne. Joanne's here. Andrew, we remind you, and then she throws the same thing back here. We remind you that this case is pending in the Southern District of Florida, not in California. We cannot agree to move the defendant's deposition from November 6th. The date was previously noticed and confirmed by all parties, and our team and the court reporter have been scheduled accordingly. We understand that you are based in California. However, defendant is represented by 2 Florida-admitted attorneys who can attend in person or defend the deposition. You may, of course, appear remotely if you prefer. In light of these facts and the existing discovery schedule, we intend to proceed on November 6th, as noticed. Regarding other additional matters to discuss, and time permitting, we include the following. 1, defendant's failure to provide amended answers or to RFAs. I don't remember what these even are. Defendant's failure to provide amended answers to ROGs, requests for original, I don't know. Defendant's incomplete, deficient document production, and failure to provide any metadata or hash values from the time of collection. This is meaningless technobabble. Defendant's failure to provide any contact information for individuals identified in his initial disclosures. Pixie's closer friends with all of these people than me. Like, I don't have I don't even know. They're like mad that I didn't give them phone numbers. I don't know these people's fucking phone numbers. Like, who are you having trouble contacting? What? Defendant's failure to provide any responses received from multiple non-party subpoenas. I don't even know what the fuck this is in reference to, but okay. Andrew. Joanne. We don't need your agreement to take Mr. Bunnell's deposition off calendar so that it can be scheduled close in time with plaintiff's deposition. If you are unwilling to cooperate, we will seek court intervention. Not only is it simply a matter of common courtesy and professionalism to avoid inconveniencing parties and counsel with unnecessary travel, it is a matter of common sense and practicality that plaintiff refuses to make herself available for deposition in Miami, where, as you point out, she filed her lawsuit at any time during the month of October, and then refuses to coordinate the parties' respective depositions in November is unreasonable. Regarding the additional matters you wish to discuss, please see our letter, correspondence dated September 22nd to September 30th. To date, we have not received responses from you or your co-counsel. At 9 a.m. PDT on October 7th, 2025, all counsel of record met and conferred telephonically on telephone to discuss the dispute over deposition scheduling. To further accommodate plaintiff and her counsel, the undersigned agreed to permit Bunnell's deposition to proceed first on November 24th, to be followed by plaintiff's deposition on November 25th. Plaintiff's counsel rejected that proposal, too, and maintained that Bunnell's deposition would proceed on November 6th, regardless of when plaintiff's deposition would be taken. Accordingly, following the parties' meet and confer conference call, Bunnell noticed plaintiff's deposition for November 3rd. So what we did after this is like, okay, you're not going to agree to anything. You're just going to fucking play games. Well, fine. We're just going to file with the court and say, well, we're going to notice your deposition for November 3rd. Hope you show up for it. Good luck. And they didn't. They skipped it. So that's why we're filing this now to cancel mine. Because fine, if you want to play games, we'll fucking play games. Whatever. They should have filed a motion to contest our noticing of her deposition. I don't know if they're just buried in paperwork or they've just given up on this case completely or they just are bored and they don't want to do it, but now she skipped her notice deposition and I don't know, good luck. So then after they were like, we're not going to produce Pixie, we'll figure it out later, your client is noticed, whatever, then Andrew emailed her and said, okay, well, dear counsel, please see the attached notice of deposition. Thank you. Notice. Please take notice on November 3rd. You better show up. Good luck. So your people actually flew out for this? Yesterday, yes. Because we had to be ready just in case she actually did show up, but she didn't. On October 8th, 2025, Ms. Peters sent the undersigned an email demanding to know what defendant's position is about plaintiff's anticipated motion for protective order to prevent plaintiff's deposition from proceeding on November 3rd, 2025, as noticed. In her email, Ms. Peters falsely speculated that Bunnell's desire to have both parties' depositions occur close in time was for strategic reasons. She further falsely claimed that defendant insists on first deposing plaintiff. I don't think that was ever the case. All of these things that we'd agreed to was her first and then me. And then now when we noticed it, we noticed it before mine so that if she missed it, now we could do this notice because they want to play games on it. But I think it's ordinary. Somebody, my litigators in chat could tell me. I think it's ordinary. Usually the plaintiff is the one that is deposed first, generally. But whatever. I mean, this case is such a fucking joke anyway. Who cares? Fuck. Where was I? We did M last, so now it's N. Joanne writes, on October 8th. Counsel, pursuant to Local Rule 7.1A3, please advise what defendant's position is about plaintiff's anticipated motion for protective order pursuant to Rule 2016 in connection with the unilaterally noticed deposition of plaintiff on November 3rd, despite knowing her unavailability. So she's saying that we're going to motion to stop your deposition notice for Pixie. We're going to file this because you guys you noticed her deposition. We didn't even agree on it. She's saying, we're going to tell us what you're going to do. We're going to file a motion about this. This was on October 8th, by the way. It's like a month ago, okay? Where was that filing? Did they not file it? To summarize plaintiff's position, we believe that your claim that you are unable to come to an agreement with us about a reasonable date of deposing of plaintiff is unreasonable and disingenuous and does not justify your unilateral noticing of the deposition, especially after plaintiff courteously agreed to depose defendant at a date of his choosing. That was before you told us that, oh, by the way, I can't be there. Cringe. This professional courtesy was clearly not returned because you wished to depose plaintiff prior to defendant's deposition for strategic reasons. We have no reason to believe otherwise. This is just a fucking lie. She's just lying about everything. It's just... Have you seen Juice Stalker coping about how he doesn't need to read the released hearing transcript? Yeah, of course. They don't want it to cover anything. This is like dead. They don't care about any of this now because now
the more and more has gone on. Like, Pixie's full of shit. She's a disgusting human being, right?
We have no reason to believe otherwise because we have offered numerous dates during the month of November, well before the discovery cutoff, for plaintiff to make herself available for deposition. This included November 7th, remote, November 14th, remote, November 21st, in person, November 21st, or 24th in person, and November 25th in person. It's difficult to conceive that no lawyer at your firm is available on any of these proposed dates, and you never explained your refusal to agree to any of these dates. And he did explain. He said, why would we have these depositions 3 weeks apart? We'll do those dates if you want, but let's do my client, the defendant, me, 2 or 3 days before Pixie's here. Like, we can just do that, right? You're the ones who played this game, this trick of getting us to agree to the 6th, or saying that we'll hold the 6th, and then saying, oh, we're not going to be able for 3 weeks later. Fuck you. It's cringe. You, in fact, confirmed that you were available on November 24th and 25th, but insisted that defendant's already noticed deposition be moved to November 25th, clearly because defendant insists on first deposing plaintiff. These positions are unreasonable, and depositions may only be unilaterally noticed if the noticing attorney acted reasonably. Moreover, your position, the defendant's counsel, would be inconvenienced by having to travel to Miami twice if plaintiff's deposition were to be held on November 21st, 24th, or 25th, and defendant's on November 6th, has no validity. Your travel preferences are not good cause under Rule 26C to reschedule defendant's properly noticed and agreed deposition, or insist that plaintiff's deposition be in the same week, particularly where local counsel is available. I like how she's saying that my lawyer's traveling is not reason for me to be inconvenienced, but the plaintiff herself traveling to the venue that she filed the court case. I don't choose where to get sued. She chooses the venue. Hers would be inconvenient. That's hilarious. Destiny, what do you think their intention is here? Stop asking me this. Why do I keep having to repeat myself? Her goal is humiliation, reputation destruction, and wasting my money. That's the only thing. She's abusing the court system to play this game, to do. That's all she wants. This is very cleanly obvious at this point. That's it. Your travel preferences are not good cause under Rule 26C to reschedule or insist or particularly counsel. Should plaintiff's deposition not be moved to November 21st, 24th, or 25th in person, or alternatively 7th or 14th at remote, as proposed by plaintiff will request in the same motion leave to attend her November 3rd notice deposition remotely, given defendant's position that it would be inconvenient for defense counsel to travel to Miami twice. Should you refuse to agree to such a remote deposition, please articulate your reasons, such as any asserted prejudice for your refusal. Since the parties have already attended one telephonic meet and confer on this dispute, we believe that any further meet and confer is likely futile. Imagine opposing counsel being like, we don't even want to talk on the phone, there's no point. Nevertheless, we are still reaching out in good faith in an attempt to resolve this dispute without the need of court intervention. That was up to N. In response to Ms. Peters' baseless assertions, the undersigned informed Ms. Peters that Bonnell had no objection to his deposition proceeding first, so long as both depositions could be scheduled close in time to avoid unnecessary travel and expense. The parties' respective depositions can either be conducted during the week of November 3rd or on the 24th or 25th, in any order plaintiff wants. On October 10th, 2025, Ms. Peters indicated, how does anyone look at this and not see the game she's playing? Because nobody reads court filings. Nobody does all this shit, right? On October 10th, 2025, Ms. Peters indicated in an email to the undersigned counsel that the reason plaintiff will not agree to conduct Bonnell's deposition on November 24th, 25th is because she and her co-counsel are not both available on those dates. Emphasis added. Previously, plaintiff's counsel indicated otherwise. Exhibit O. I think, is this one we've already read, or? No. Oh, okay. So she said this was the last one we just read. Another meet and confer is pointless. Wait, you skipped Andrew's response. Did I? On N? Oh, I did. Wait, did I? I did. Okay, it's included in this one anyway. Doesn't matter. Okay, so in response to her email here saying we shouldn't even do another meet and confer because it doesn't matter anyway, Andrew writes on October 8th, Joanne, No objection to you deposing Mr. Bunnell first, even though it's customary for a plaintiff's deposition to be taken before defendants. I tried to make that clear during the call yesterday, but I was continually interrupted. Hurt. Even the voice conversations are unhinged. The only issue is coordinating the scheduling of the two depositions so they occur during the same week. We'll even leave it up to you and your client. The parties' respective depositions can either be conducted during the week of November 3rd or November 24th and 25th in any order plaintiff wants. This whole court case has been her playing legal games the entire time. Whatever you want to do, we can do it. But they're just playing games. It's so stupid. It's because they're so it's just, I hate my life, dude. This is how much my life is wasted on that. How much money and opportunity cost. But I mean, that was her goal, I guess, and it's epic. So. You offer the defendant can depose plaintiff remotely is not acceptable. Plaintiff filed a federal lawsuit in Miami, Florida. Defendant is entitled to take her deposition there. Quote, the general rule is that a plaintiff who brings a suit in a particular form may not avoid appearing for examination in that form, end quote. Quote, in accordance with this general rule, a plaintiff must make herself available for deposition in the judicial district in which she filed suit, end quote. We hope plaintiff will reconsider her position. Thank you, sincerely, Andy B. Joan Peters, thank you for your response. As we informed you prior to your noticing plaintiff's deposition for November 3rd, she is not available in Miami or remote on that date and will not be appearing. She is available on November 21st, 24th, and 25th in Miami. We plan on proceeding with the agreed and noticed deposition of defendant on November 6th. And while we understand you might be inconvenienced by having to travel to Miami twice, the fact remains that this matter is pending in Miami. Defendant resides in Miami, and defendant is a local counsel in Miami. You have not presented any good cause reason to change an agreed deposition date or to insist that both depositions take place during the same week. Carlos and I are not both available on the 24th and 25th, and thus we cannot agree to moving defendant's deposition to one of those days. Do you see how much I feel like a stupid game this plays? Like how fucking stupid this is? It's so cringe. Like, hey, do you want to go out to eat? Do you want to go out to eat for pizza on Friday? And you're like, yeah. You're like, okay, cool. I'm not available Friday. I can either go eat on Wednesday or Thursday. When do you think I should go eat? It's like, oh, I thought we were eating together. I guess I'm available on Wednesday or Thursday, so we can go there. No. Excuse me. You said that you were going to go Friday. I want to know when I can go on Wednesday or Thursday of next week. It's like, well, I mean, I only thought we were going to go out to eat together. Why would I go eat alone? I'm not going to go Friday on my... No, that's not what this conversation is about. You said Friday, you're going Friday, and we're deciding if I'm going to go on Wednesday. It's like, well, this is like to see real... It's so cringe. Yeah, this guy in chat, I can't believe I'm seeing a lawyer do no takesies, backsies. It's unironically, it's that. No takesies, backsies. You said the 6. We agreed. No, it's like, oh my God. Seriously? Is this for real? We're really doing this? After hearing nothing from plaintiff's counsel for several weeks, on October 27th, 2025, Ms. Peters emailed the undersigned reiterating her objection to plaintiff's deposition proceeding as noticed on November 3rd. So I guess she just stopped responding. She didn't respond to Andrew. So this was October 8th was the email. And then she wrote on October 10th. Oh, and then Andrew responded, plaintiff's position is unreasonable. We will leave it up to the court to decide. Destiny, why don't you want to do remote? Because I have a right to take her deposition in person. Why would I accommodate her schedule? She filed her suit against me in the Southern District of Florida in federal court. So I'm going to take her deposition here in Florida. I'm not going to make accommodations for her while she frolics off to go do law school in another state across the country while she's just getting to do whatever the fuck she wants and to dilly-dally around in her life while she tries to destroy mine. No, this is the venue that you sued me in. So this is the venue where we're going to physically sit in person and have our depositions done in. And I don't want to risk. Why would you risk? I don't know if there are lawyers in here that have ever done like remote depositions where like, what if we ask a hard question and her thing like disconnects or there's like, she's getting coached to the background. Like, no, why would I'm not going to do why would I do a remote deposition? Cringe. So on October 10th, Andy said, plaintiff's position was reasonable. We will leave it up to the court to decide. Destiny, is it a problem for your California lawyers to attend remote? No, I don't want my lawyers to attend remote. I want to be there in person, in real life, to do a real life big boy deposition. This is court. It's not a Zoom call. It's not a Twitch stream. It's not a Discord meet. You're suing me. We're going to sit down in the same fucking room and we're going to do a deposition like you do in court. That's what we're doing, okay? It's not a game. $20 days later, or not 20 days later, I'm sorry, 17 days later, 2.5 weeks later, counsel, on October 7th, we held a meet and confer regarding plaintiff's deposition date. During and prior to that meet and confer, we informed you the plaintiff was unavailable to Deposed Miami in person during the week of November 3rd. We offered in-person dates November 21st, 24th, 25th, as well as several earlier remote deposition dates immediately following our meet and confer. And despite knowing plaintiff's unavailability, you sent a notice of deposition for plaintiff on November 3rd. Based King, by the way, based and King. On October 8th, we again informed you that plaintiff was unavailable on November 3rd and would not be appearing. On October 10th, defendant's counsel stated by email that we will leave it up to the court to decide. The notice deposition date of November 3rd remains a date on which plaintiff previously advised she's unavailable. Plaintiff continues to stand ready to appear on any of the 3 alternative dates previously provided. Please promptly confirm one of these available dates so that we can plan accordingly and reserve the date. Otherwise, we will proceed to open our calendars to other matters for those dates. Andrew, same day. Same day. Hold on. 4 minutes later. Damn. Assuming these are the same time zones. Joanne, we intend to proceed with plaintiff's deposition on November 3rd, as noticed, unless you file a motion for a protective order. If you'd like to agree, as we've been urging for quite some time, to schedule both plaintiff and Mr. Bonnell's deposition during the last week of November, we remain amenable to doing so. What a reasonable position. The undersigned responded to Ms. Peters indicating the intent to proceed with plaintiff's deposition as noticed on November 3rd, unless plaintiff sought a protective order from the court, or agreed to coordinate the parties' deposition scheduling, as the undersigned had repeatedly offered. Later that day, and notwithstanding plaintiff's counsel's prior inquiry into Bonnell's position with respect to plaintiff's contemplated motion for a protective order, plaintiff's counsel replied, we will not waste the court's time or plaintiff's resources by filing a motion for a protective order. Wait, did she really say that? I don't even think I've seen that email yet. Wait, did I miss one of these? Exhibit Q. LMNOP. Destiny, it's not without precedent to do things over Zoom. What's your reasoning besides it requires big boy pants? I want to have a deposition in person. There's a different energy to speaking to somebody in person. I want to make sure that that she is having a conversation with my counsel, that she's not being coached, there's no weird stuff going on in the background, that she can't push the disconnect button on the call, that there's not any, weird shenaniganery going on, that it's a deposition with a one-on-one, having a conversation, taking notes, writing down everything, having it recorded by the court reporter as a standard deposition is done. Counsel. Oh wait, this is docket item 17. A different thing, okay. The undersigned responded indicating that if plaintiff failed to appear for her notice deposition on November 3rd, that Bonnell would ask the court reporter to record a certificate of non-appearance for the record and proceed according before this court. Oh, okay. This was Joanne Peters. So Andrew says, listen, we've noticed your depo for November 3rd. Okay. If show up or file a protective order and ask the court to intervene. Because now, if we're going to play games, well, then we'll play games. Fine. Andrew, and then Joanne says, Andrew, we will not waste the court's time or plaintiff's resources by filing motion for protective order due to your unilaterally scheduled notice of deposition. You were fully advised prior to sending your notice of deposition that plaintiffs are not available to depose on November 3rd, and you have since been fully advised that plaintiff will not be appearing on November 3rd. Unilateral scheduling of depositions, particularly where the despondent previously notified her unavailability and provided alternative dates, are frowned upon by this court. And he says, Joanne, if plaintiff fails to appear for her deposition, it's Joan? Okay. If plaintiff fails to appear for her deposition on November 3rd, we will ask the court reporter to record a notice of non-appearance and proceed accordingly. That was on this. Notwithstanding the foregoing correspondence and the fact that plaintiff still had not filed a motion seeking a protective order, on October 29th, 2025, plaintiff's counsel sent an email inquiring about the attendees at Bonnell's deposition. Fuck, I don't know if I've seen this one either. Wait, what the fuck? We might have talked about this. Exhibit R. Did they really? Let's see. Joan. Reference is made to your email of October 29th, 2025, in which you inquired about the attendees at Mr. Bonnell's deposition. Please be aware that unless plaintiff appears for her deposition as noticed on November 3rd, we will not be producing Mr. Bonnell for deposition on November 6th. Thank you. Wait, fuck. Is that email anywhere? October 29th? Oh, fuck. Did that one not get posted anywhere? Oh, shit. Uh-oh. The undersigned responded to plaintiff's counsel by email on October 30th, reiterating that unless plaintiff appeared for her notice deposition on November 3rd, Bonnell will not be appearing for deposition on November 6th. Okay. On November 3rd, 2025, the undersigned appeared in Miami, Florida for plaintiff's notice deposition at 10 a.m. EST. The undersigned was prepared to take plaintiff's deposition, but neither she nor any of her counsel of record appeared pursuant to the notice. The undersigned waited until 10:30 a.m. before concluding. At no time prior to the commencement of plaintiff's notice deposition did she file a motion seeking a protective order. Indeed, plaintiff's counsel previously indicated that they would not waste time or resources doing so. Based king. A protective order coordinating the parties' depositions is warranted. Pursuant to Rule 26C, a party or any person from whom discovery is sought may move for a protective order specifying terms, including time and place of a deposition. The court has the inherent authority to issue an order specifying the time, place, and sequence of depositions to protect a party from undue burden or expense. Moreover, the Federal Rules of Civil Procedure authorize the court to compel a party's deposition where that party fails to coordinate in scheduling. Blah, blah. Indeed, courts here routinely exercise their discretion to coordinate depositions occurring in the same location or involving overlapping issues. Federal Rules of Expression are very broad. These are just law things. There's also a strong presumption that a plaintiff must sit for deposition in the forum where she chose to file suit. Plaintiffs are required to make, again, and this is what he quoted Joan in emails. Critically, when plaintiff refused to reschedule the depositions, plaintiff and her counsel had two choices. One, appear for her notice deposition, or two, seek a protective order. Plaintiff did neither. Citations. A party's failure to appear for her duly noticed deposition without obtaining, let alone seeking, a protective order was not substantially justified. Under the circumstances, reasonable people could not defer as to the need to at least seek a protective order, particularly when the deposition notices were received several weeks in advance. Here, both plaintiff and her counsel of record failed to appear for her deposition as noticed on November 3rd, 2025. Further, plaintiff failed to seek a protective order at any time prior to the commencement of the scheduled deposition. Counsel for Bonnell spent significant time and resources preparing for the deposition, traveling across the country, and scheduling a court reporter. Despite plaintiff's recalcitrance, she now seeks to force Bonnell to appear for his own deposition on November 6th. In the interest of fairness, judicial economy, and the convenience of all parties and their counsel, the court should issue a protective order directing that the deposition of plaintiff and defendant be conducted during the same week, preferably November 24th and 25th, 2025, respectively, in Miami, Florida. Indeed, plaintiff has already represented that she is available for deposition on those dates. Bonnell is entitled to reasonable attorney's fees and costs. Pursuant to Rules 26C and 37A4 of the Federal Rules of Civil Procedure, this court has discretion to impose sanctions. I think we're starting to ask for this more in motions now. In the form of attorney's fees and costs associated with bringing the instant motion against plaintiff and or her counsel for 1, their failure to coordinate scheduling of the deposition of this case, and 2, their failure to appear for plaintiff's duly noticed deposition on November 3rd, 2025. The court should issue an award of sanctions accordingly. The 11th Circuit has explained that Rule 37 sanctions are intended to prevent unfair prejudice to the litigants and ensure the integrity of the discovery process. Sanctions are warranted here. Plaintiff's conduct has forced Bonnell to incur significant legal fees and costs in preparing for, traveling to, and appearing for plaintiff's deposition. Bonnell has incurred attorney's fees and costs in excess of $10,875 in connection with plaintiff's failure to appear for deposition and having to file the instant motion and supporting documents. Bonnell respectfully requests that the court issue sanctions against plaintiff for her misuse of the discovery process. Conclusion. For the foregoing reasons, Bonnell respectfully requests that the court issue a protective order directing that the depositions of plaintiff and defendant be conducted during the same week, preferably November 24th and 25th, respectively, in Miami, Florida. Bonnell further respectfully requests that the court award Bonnell his reasonable attorney's fees and costs incurred in bringing the instant motion. There you go. Damn. Somebody said they just filed a new thing. And then this is the certificate of... Was this what the vague posting was about, or is there more coming? This was not what it was about. There is more coming, one. And there's another vague post, more coming, two. There's a lot of memes in the pipeline right now. All of it very, very, very bad for the two main parties involved on the other side of this. Plaintiff's reply to docket item 153. Response in opposition to motion, response in opposition to motion to dismiss, and motion to submit auto files conventionally. What the fuck is this about? Reply to 153. Response. How many fucking responses do they get to this? Response in opposition to plaintiff's motion. Oh, whatever. I don't know. Okay. Jane Doe. Plaintiff Jane Doe conventionally submit audio files conventionally motion. Okay. Defendant's opposition contends that 1, the original video links cited in plaintiff's opposition to motion to dismiss were not authenticated, and thus neither can the audio files be authenticated, and the court's order does not require retroactive refiling. Motion to dismiss did not raise any objection. I think there are 2 video links that were included in the... Oh, it's just her reposting. Is this like the food shops links? Okay. Is that all this is? What are they even hoping to prove here? Nor does plaintiff's motion seek to retroactively refile exhibits. Far from attempting to reopen or refile prior submissions, plaintiff is attempting to preserve the integrity of her opposition by submitting the same content in an accessible format. Plaintiff's motion does not seek to supplement the record or introduce new evidence. It simply requests leave to conventionally submit 2 short audio clips that were already cited in her opposition to the motion to dismiss. Why didn't you submit them then? Indeed, if the video links had not been deliberately privatized by one of defendant's followers, solely in order to thwart the plaintiff and prevent the court's access, it would not be necessary to submit them conventionally. Why are you just linking things to the court? You can't just send YouTube links and say, Judge, go check out this video. What are you doing? What the fuck is it? Why wouldn't you have your own backup? Why wouldn't you create stuff of this? What if the other person got banned? Would you just lose your court case? The judge already warned them about that? Yeah. Jesus Christ. Moreover, submitting the audio files conventionally complies with the court's instruction that links should be included as exhibits rather than URLs. Plaintiff's motion is procedural and corrective, not substantive. Wait a second. Moreover, submitting the audio files conventionally complies with the court's instruction that links should be included as exhibits rather than URLs. Wait, am I misunderstanding what the judge said? I thought the judge wasn't saying that you need to submit links as exhibits rather than URLs. I thought the judge was saying you need to submit the files themselves. You can't link me websites. See, ECF 143, page 15. Talking at 143, page 15. Is it really in the last? It is further ordered that as to any links to images or online documents, and on an ongoing forward basis, the references linked to must be included as exhibits to filings. Oh my God, she's so stupid. Joan, the judge isn't telling you that you have to submit a separate exhibit with a link. He's telling you that you need to submit the material linked as an exhibit. Are you not a practicing attorney or an immigration attorney law? Do you not file paperwork? What do you even do for work? Oh my God. No shot did she, I'm sorry, am I misunderstanding this? Well, hold on, I can just check. Oh my God, what are you doing? No, this is not what the judge was saying. And they're still just posting their legal shit from Kiwi Farms. What is wrong with you? You're so fucking stupid. I hate her so much. Check the exhibit attached. What, like... Subsequently, I located reposted copies of excerpts of the same videos on the Kiwi Farm social media platform. You located? Like you went and looked for these? That's not true. You're just getting fed all of this from Kiwi Farms itself. I like how they're acting like I went out of my way and managed to scrounge this up on the internet. This is what Pixie is submitting to the court. First of all, that YouTube large site still reports Destiny's channels as demonetized. If this is a prank, it's starting to cost him actual money now. Remember, this is all Pixie's goal is. Code Cave, remember, that's somebody else that they've copied. Their expert witness, Jesus Pena, who lied about doing his own expert witness report, copy-pasted Code Cave's analysis of the links to prove that they were fake. Code Cave, he's claiming all these editable file names in a random spreadsheet he made are accurate timestamps, in which case some other autist should double check these dates in case he has other victims. Huh, it's almost like when everybody's double checking everything, I haven't made anything up. Kind of crazy, huh? It probably goes without saying, but this spreadsheet is 100% Destiny's handiwork. I doubt his legal team had any hand in it, other than suggestions on how best to present it. He actually worked on building these spreadsheets from December 8th through the 10th while he was lurking in Food Shop's Discord, and he kind of gave away how he built some of the exhibits he included in his recent motion. According to him, he had to marry up records from Discord to records he had from Redact to reconstruct a continuous chat timeline. I don't think he ever mentioned Redact at all in his legal filings. In my opinion, that he had to reconstruct anything at all would point to the evidence being not totally reliable, if only due to potential mistakes on his part. Then prove it! Demonstrate. You can't just say every single thing I do is not reliable. Then prove it. Demonstrate a single false submission, a single thing that's inconsistent with any other evidence or any other part of the record. Anything at all. A single thing. I don't know why I'm screaming at this. They're playing, these are all games, right? Here are clips from Food Shop stream dated September 8th. I'll include timestamps of the original video on YouTube. Here, they always misgender her because they're transphobic as fuck, but great. Here she talks about using ChatGPT to format data. Oh, no, I'm sorry, wait. They were talking about me in this video. They do misgender her, but this is them talking about me. Here he talks about using ChatGPT to format data into a spreadsheet a certain way. Of course, he makes a child porn joke. Here he talks more about what files he's working with. He mentions Discord log exporter, actually Discord chat exporter, and Redact. He says he's trying to, for a nice presentation, recreate a singular log file. Huh? Why does he have to do this? Was the original log file tampered with in some way? The reason why I have to do this is because typically the logs are only exporting one side. I don't even know why I'm responding to this. I think Justicle's retard, esports Batman, and all these dipshits say the same thing. Oh, I thought Destiny said he exported from Discord. When you request a copy of your own data from Discord, they only send you your side of the conversation. It doesn't include the other person's side. So I can use Discord chat exporter to export their side, and I have Discord log exporter that shows my side, but they're using different timestamps. So I have to merge these together for a single readable chat log, and then that's what I give as my discovery production. If they don't like it, then you can either show me what's wrong with it or kick rocks. The fuck? You're not submitting any evidence for anything. Choice quotes from Destiny. You don't understand. Information is lost. Information is lost. There's no original file. I'm trying to restrict file. When I say information is lost, what I'm saying is if you're creating, you can't create Unix time codes from ordinary human time, if you're not taking into account the daylight savings time shit, you can't, like, going backwards like that doesn't really make sense, because you could, and that was an issue. I don't know if Discord was doing that or if Redact was doing that, but it's annoying because I realized that just using Unix timecodes, it wasn't lining up because one of them wasn't correctly recording the daylight savings time. But they're trying to act like I'm like adding information, or I'm inventing logs here, or I'm like inventing, you know, messages. But it's like, oh, okay, well, if you think I'm doing that, then demonstrate that somehow. Show me. But great. Okay, cool. I can't believe that. I can't believe that she is so stupid. I can't believe she really is so stupid. Joan doesn't know how to read, or plaintiff's motion not seeking to, okay. Moreover, submitting the audio files conventionally complies with the court's instructions that links should be included as exhibits rather than URLs. Do you understand what I say? Do you understand what I'm saying here when I'm saying she's misunderstanding what the judge is saying? The judge was saying here, guys, if you're going to submit evidence or whatever, then give me a USB drive, or give me, to be honest, it's weirdly phrased. Shut the fuck up, you retarded fuck. I don't care if you're in grade school. Shut the fuck up. This conversation is not for you. It's very obvious what the judge is saying here. It is further ordered that as to any links to images or online documents, and on a going forward basis, the references linked to must be included as exhibits to filings. The references linked to must be included as exhibits to filings. For security reasons, the court will not open random links to Imager or Google Drive. Should a party believe any exhibit should be sealed, they may file a motion seeking leave of court to file it under seal, as with any other filing or exhibit. Oh, wait, hold on. Okay, never mind. I take back my mean comments about Joan. I think she is putting links here, but I think she did send in a USB drive, I think. I personally reviewed the audio files and confirmed that they accurately reproduce the same content I observed in the original 2 videos and reposted copies. I then uploaded the audio files onto a USB drive. I'm assuming she sent that to the court in conjunction with this, I think. Hopefully she did. What the fuck is this even for? What are they even fighting about this? Oh, this is just their response to our motion to dismiss by trying to impeach the evidence that I'm providing. But didn't the judge still say there shouldn't be actual links in the filings? Yeah, well, he said they're not going to click any. But it's probably not necessarily bad for her to include links, as long as she also includes stuff on a USB drive. Maybe? I don't know if she should include the links or not. Or maybe they should just be in a footnote, maybe? I don't know. On or about October 15th, 2025, I provided the link to the Kiwi Farms post by Latrell Spreewall to our firm's IT engineer, Mr. Benjamin Wass, for the purpose of creating an audio-only version suitable for filing with the court. Mr. Wass downloaded the clips directly from the Kiwi Farms link and then used an online converter to convert the MP4 to MP3 files and sent the 2 audio files to me. Okay. They're so desperate. Destiny, I think she's still in the process of trying to send it to court because there should be a docket entry, just like there is one when you send them a USB drive. Okay, maybe she hasn't yet then, I guess. I don't know what the fuck this person's doing. Well, there must be, right? There has to be a docket entry, I guess, if they're submitting. So then she hasn't submitted USB drives yet? She just like shot him some more links and said, yo, check this out. And then the USB drives are on the way. You can't submit video, or why are they converting MP4 to MP3? I have no idea. They could probably submit a video file. I don't know why. I don't know anything. This person is just, all these people are crazy. Okay. 164 docket items, 9 months into this case. Based. King, queen. Okay, am I good? We're good with this for today? Jesus. Had you read the 160 on stream? I don't even know. Did we? What was this even about? Oh, they filed something that was late to try to do like a more protective order. Oh shit, wait. This was she wants a public gag order on the case. And they filed for one a long time ago, but it never got approved. Plaintiff's motion seeks a narrowly tailored protective order to curb the ongoing harassment, doxing, and intimidation that threatens the integrity of these proceedings and is causing further harm to plaintiff. She still has her GoFundMe, by the way. She still has that literally pinned on her fucking Twitter. But good one, okay. In support of the motion, plaintiff submitted evidence to defendant's online harassment and doxing of plaintiff's witnesses and potential witnesses, and plaintiff's counsel. Plaintiff's counsel? I'm doxing her counsel now? Defendant has recently engaged in additional online conduct that underscores the necessity of the requested protective order. Specifically, on October 29, 2025, defendant published on the social media platform X a post identifying plaintiff's spouse by her legal name. So the fuck what? Protective orders are not here to protect your name. Protective orders exist to protect your identity, to shield your identity from the public. You've already made public. This is why I'm saying the whole protective order, all of this is just a fucking game. Like, imagine if Pixie were to join a company called Tankies for the Destruction of the Democratic Party in the USA, but she joins under her real name. And imagine I tweet out and I'm like, oh my God, wow, look at this. Pixie's joined Tankies for America, good job. And now they're like, oh, well, we're filing a lawsuit or we're filing another protective order. You just linked to her real name. It's like, this is so stupid. Well, like, the protective order is not here to hide doxing. That's not a real thing, doxing, for a court case. In a court case, you're supposed to make your identity known to the public. You're filing in a public forum. Accompanied by a screenshot from an Instagram post depicting plaintiff and her spouse. It's a public Instagram post, along with a private chat thread between defendant and plaintiff from October 2023. Defendant only included the message from plaintiff and omitted his own responses. See Exhibit A attached here too. The spouse's social media account is not in her legal name, but instead under a pseudonym. Defendant nevertheless deliberately identified her. The spouse's there's her spouse. She's not part of this court case. Thereby linking plaintiff's pseudonym in this litigation to her spouse's true identity and effectively disclosing identifying information that this court's protective order was designed to safeguard. No, with regards to court filings, this is about seals. That you never got the gag order that you wanted. That's not true. The defendant then falsely and maliciously accused plaintiff of having committed a green card marriage fraud. She has, by the way, and she did, by the way. That's why if you check any of Virginia's social media today, she has nothing to do with Pixie. She hasn't talked with her for a year. And apparently Pixie doesn't even live in fucking Florida anymore. They 100%, and for other reasons that I can't say publicly, but they 100% committed a green card fraud marriage. I don't even know if Pixie's fucking bisexual. She just fucking married her friend because she wanted her to stay in the US. She wanted to get her a green card, by the way. Unban this guy. There you go. If you get legal fees, would you be able to collect from her spouse? Maybe, so that's kind of cool. But we'll see. The defendant then followed Exhibit A, the post has been viewed 498,000 times. Immediately behind me, and another reply to defendant's post has posted plaintiff's legal name and other identifying information. It's not me posting it. What do you want me to do? All of this shit is public information that you have posted on your social media platforms. Immediately upon being made aware of defendant's post on October 29th, did you hire a private investigator or something? No. Maybe I'll be able to, in several months, I'll be able to tell you. That would be the third extra super meme thing coming down the pipeline, okay? We'll see. Dr. Joan Peters. Ms. Peters' email includes a screenshot of the post and asked counsel to instruct their client to immediately remove the post. Mr. Brettler's response asserts that the post did not violate protective order because it only pertains to documents filed with the court and not to social media posts. Moreover, Mr. Brettler contends the court has not yet ruled on plaintiff's pending motion. There is no restriction on defendant's public commentary. Furthermore, the protective order requires that under no circumstances shall any person disclose plaintiff's name to the media without consent of plaintiff's counsel. Defendant's deliberate disclosure of the spouse's legal identity, a family member whose identity is necessarily related to plaintiff, constitutes an intentional breach of the order's confidentiality mandate and a continuation of the very harassment plaintiff sought to prevent through the pending motion. Remember, plaintiff still has her literal thing pinned saying that she's suing me for revenge porn. Like, it's publicly on her fucking Twitter, right? Like, she's not trying to use a protective order in the spirit of the protective order. She's just trying to use it to think she can trip me up on if I make a boo-boo or a mistake. It's so stupid. It's so cringe. Whatever. The new posting exemplifies defendant's ongoing campaign to publicly expose and disparage plaintiff and those associated with her, further justifying the need for the broader protective measures requested in the pending motion. Oh, like what you're doing in this whole lawsuit that you've even stated publicly. This incident mirrors the type of conduct that the motion seeks to prevent and further demonstrates the ongoing risk of prejudice to the integrity of these proceedings and the plaintiff's safety and well-being. Oh my God. Plaintiff respectfully requests that the court take note of... Okay, there's that. Filed under seal. Maybe this is just my tweet, I guess. Okay. And then the last thing was just Andrew's response to that. And then we're done, okay? On October 30th, 2025, plaintiff Jane Doe filed an untimely notice of expiration, an unauthorized cert reply brief styled supplemental evidence in further support of plaintiff's pending motion for a gag order against defendant Stephen K. Bonnell. The second, plaintiff filed her motion for a gag order nearly 5 months ago, and her transparent attempt to use Local Rule 7.1 as a pretext for filing her unauthorized cert reply brief should not be permitted. The court should strike plaintiff's pleadings in their entirety. First, Local Rule 7.1 imposes a burden on a moving party to file within 14 days of the 90-day expiration date, a notification of 90 days expiring. Plaintiff filed her motion seeking a gag order against Bonnell on June 2nd. Bonnell filed his opposition on June 16th. Plaintiff filed her reply on June 23rd. The court did not schedule a hearing on the motion. Accordingly, the 90-day period expired on September 21st, 40 days ago. Plaintiff is just now getting around to complying with the court's local rule. Second, Local Rule 7.1 requires the noticing party to provide specific information pertaining to the fully briefed motion, including the title and docket number of any and all responses or opposing memoranda. In her so-called notice, plaintiff failed to provide the prerequisite information, blah, blah, blah. Substantively, plaintiff seeks to draw on benefit from public assistance while pursuing her lawsuit anonymously and seeking to muzzle Bonnell at the same time. Indeed, while seeking to silence Bonnell with a gag order, plaintiff continues to promote and associate herself and her online persona Pixie with her allegations against Bonnell while also seeking to help or to keep her legal name confidential. Plaintiff has repeatedly attacked and maligned Bonnell online, including through her Substack posts, social media updates, pleas for additional witnesses to come forward, and solicitations for donations to her legal fund, all of which have been viewed collectively more than 1.5 million times. In fact, this court has already noted plaintiff's substantial public commentary about the case. Plaintiff cannot have it both ways. Moreover, plaintiff's counsel's representation regarding counsel's meet for efforts is grossly misleading and inaccurate. Attached as Exhibit A to the declaration of Andy B. Brettler, dated October 31st, 2025, and filed concurrently here within, is a true and correct, partially redacted copy of the letter, dated October 29, 2025, that Bonnell's counsel sent to plaintiff's counsel in response to plaintiff's false contention that Bonnell violated protective order. Throughout her notice and her attorney's supporting declaration, plaintiff misstates and omits key portions. Okay. And then this is the last thing. And then we're done. His exhibit was, this was the response. Dear Joan and Carlos, we are writing in response to Joan's emails from 7:56 a.m., 10:21 a.m., and 1:13 p.m. Oh, she started spamming emails. Oh my God. PDT Today, in which she baselessly accused Mr. Bunnell of violating the protective order dated February 20th, 2025 by posting the name of plaintiff's spouse on social media and repeatedly demanded that Mr. Bunnell immediately delete his post and publicly apologize to plaintiff. He is not obligated to do so. Nothing in Mr. Bunnell's social media post violates the terms of the protective order. The protective order governs documents filed with the court. Conveniently, Joan omitted this qualifier in the portion of the order she quoted in her first email this morning. The protective order does not restrict public commentary, nor does it impose any general confidentiality obligations on the parties. Plaintiff's motion seeking to impose a gag order on Mr. Bunnell has not been granted. Indeed, in plaintiff's motion seeking to hold Mr. Bunnell in contempt for discussing the June 3rd, 2025 hearing on social media, the transcript of which was recently unsealed, plaintiff advanced a similarly frivolous argument to the one she asserts here, and that she accused Mr. Bunnell of violating a then and still non-existent court order. Mr. Bunnell opposed that motion precisely on those grounds, among others. Further, notwithstanding that the protective order did not govern Mr. Bunnell's privileged speech, he did not publish any new, previously undisclosed, or confidential information on social media or anywhere else. Mr. Bunnell merely reposted what blank previously published on her own social media pages. See this? Blank's social media account remains active and accessible and included photographs of both her and plaintiff. In fact, the post Joan embedded in her email from early this morning was taken from her Instagram page. Prior to Joan sending her email, Blank had tagged plaintiff in that post. Now she has since removed the tag, likely because plaintiff in a public post does not, because tagging plaintiff in a public post does not fit the narrative plaintiff is putting forward here. Finally, the contention that Mr. Bunnell defamed plaintiff in his post by suggesting that she engaged in green card marriage fraud is unfounded. Plaintiff admitted in correspondence she produced to this case that she was marrying blank because she wanted blank to stay in the United States. Plaintiff further expressed her concern about the affidavits and interviews that she would need to provide to establish a bona fide marriage. Given that truth is a complete defense to a claim for defamation, nothing in Mr. Bunnell's post rises to the level of an actionable claim. In any event, if plaintiff were to assert such a claim, it would be subject to Florida's anti-SLAPP law. Plaintiff would be exposed to significant liability, including but not limited to paying Mr. Bunnell's legal fees in connection with having to defend against any such claim. If it's proven that she was committing green card marriage / fraud, does it help get the case dismissed at all? Nope. It doesn't really have anything to do with our case, which is why it's also stupid for her to be bringing it up. Do your lawyers even have to respond to this shit? It's not like the judge is going to rule on defamation. Well, I mean, you kind of want to reply because you don't want to leave it replyless and then, yeah. Brettler set the mail on the 29th, and on the 30th, plaintiff still filed the thing. Sure. That's just what they do. They do be filing. Oh, and then as a final kind of meme thing, I noticed this last night. The crazy, weird, random shit. These people are crazy, bro. I don't know if it's like Lauren De Laguna is just like puppeteering all of these people in the background, but Pixie's wife is also suing her last place of employment for sexual harassment. I think she filed a suit against them, was it 6 months ago or 1 year and 6 months ago? She was also suing her. What? Jesus Christ, bro. You're being subtweeted via the lawsuit. Yep, but that's their goal, literally.